To the August 11th, 2009 meeting of the Board of Supervisors, and would you all rise and join me in the pledge? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. We have results of a closed session held on August 4th, 2009. The closed session was held pursuant to Government Code Section 54957.6, a conference with labor negotiator. This was regarding the with our Director of Human Resources and Risk Management regarding the Service Employees International Union Local 1021 SCIU, the BSA, and resulted in nothing to report. Okay, turning our attention to our agenda this morning, we first of all have the consent agenda, and as you know, the items on the consent agenda are normally routine and non-controversial. They'll be acted upon at one time. However, anyone in the audience or the board can remove an item for individual discussion. So at this time, do I hear a motion on the consent agenda?
So moved.
Of course. Which one would you like to have removed?
I have some questions about number 3.
All right, I'll move the balance then.
Second.
Okay, we have removed item number 3, and we are have a motion and a second on the other items. All in favor say aye.
Aye.
Aye. Hearing no opposition, the motion passes unanimously. And on item number 3, Bonnie, did you have a specific concern?
Well, I noticed that Jean...
Can you come to the podium, please?
I just noticed that Jeannie was here, and I thought I'd ask, since this is touching something real close. We're approving $150,000 to the Crestwood Behavioral Health, Inc. for psychiatric treatment services. The questions are, where is the $150,000 coming from, and what kind of psychiatric treatment services are we paying for?
Okay. Good morning, Jeannie.
Good morning. Jeannie Boyce, Director of the Health Services Agency. This is a contract with Crestwood, who operates different facilities for psychiatric inpatient services. And so when we need to find a placement for someone who's on a 5150 hold, who may be gravely disabled, unable to care for herself, we may we may place somebody in that facility. And they have a number of facilities. They have what they're called as Institute of Mental Disease, which are locked psychiatric facilities. They have geropsych units for people who have mental health issues as well as geropsych issues. So this is one of those contracts that we essentially enter into a contract for $150,000. It's paid for with a combination of state and federal dollars as well as county realignment dollars. We may not use the entire $150,000. We hope we don't. But we have to have facilities under contract so that we have a place if, in fact, we need someone that has to be placed in a facility. They have to meet pretty stringent requirements, as you know. Does that answer your question?
Almost. As you know, I'm still looking for funding to help people that are traumatic brain injury. We don't have facilities, and I'm always looking for a way to get my clients service, because besides not having mental health services, we don't have a daycare program, and so people that have what they call organic problems, which I call incurable crazy people, there's no services.
Bonnie, excuse me.
I'm just desperate. So.
Bonnie raises significant issues that are issues nationwide, and particularly in California. She's correct that persons who have organic brain disease don't fall under the definition of mental illness. There's a gap where people do fall through the cracks, and it's a serious problem. And I've suggested that, we continue to lobby our legislators, which we have, to change the laws, but we have not been successful to date. It is a significant issue, and I agree with you, but I don't have an answer for you.
Any other questions of Jeannie Boyce? No? Okay, the chair entertains a motion on this item.
So moved.
Second.
Okay, moved and seconded for approval. All in favor say aye.
Aye.
Aye. Opposed? Hearing none, the motion passes unanimously. Okay, we will be taking just a short break before our 9:10 point. But on item number 4, I'd like, where's the Public Works representative? Okay. There is a typographical error in this report. If you look under Jenny Lind Road, the third from the last bullet point is an item that pertains to Pole Station Road, which is the second, or the following item. So that, can you clean that up? Thank you. All right, so we'll be reconvening at 9:10. I want to draw your attention to the agenda and the fact that we are going to have a closed session, item number 12. I think that this is for the purpose of the press and anyone that's interested in the outcome of the current, the negotiations that are going on with our labor units. We may have some significant items to report out after that closed session, so you ought to stick around until we'll be coming right back after that. All right, we are at the 9:10 point on our agenda. This is public comments. I'll be limiting, as usual, the comments to 5 minutes per person, 15 minutes per topic, and anybody can come up and address the board. Good morning, Mr. Ginger.
Hey, one of the things, I think you guys ought to bring the old officers back and take these other cops and put them out on the road, because the other cops, they know their stuff. And I've heard there's been some mishaps out front, a couple of them already. But I just got to tell you, the guys are good guys, and they need to keep their jobs. And the other thing is salvaging. I was told there's no salvaging at any of these county dumps. It's mandatory that they don't. And there's a guy up in Wilseyville that showed my friend of mine a check for $1,600. Now, if that's every 2 weeks, if you guys took the jailers out there and salvaged that, you guys could bring $4,000 or $5,000 a month home that you guys could put these cops or somebody else back to work. Because it ain't right. It's not right at all. And I heard the big dump, the guys got a trailer on the county property loading stuff and taking it once a month to the dump. Hey, if we need the money, let's stop these guys from doing it, because we do pay them a wage. Okay, thank you.
Thank you, Mr. Ginger.
Always.
Hi, my name's Marlene Bronner. I'm with the Central Sierra Child Support Agency, and I wanted to make everyone aware that August is Child Support Awareness Month, and to give you a few facts and figures of what we do. We're a quiet little agency nobody ever hears much about. There are 1.8 million children in California that are serviced by the Department of Child Support. Of that, 2,355 children within Calaveras County are serviced by our offices. We do cover Alpine, Amador, and Calaveras, all three. The total amount of current child support that's due to the children in these three counties is $3,315,795. Excuse me, it's a lot of money. Of this total due, we have distributed $1.9 million, or 58%, to the children within these three counties, so it's a positive thing we're trying to do to get some money to the kids. The total amount of child support arrearages owing to the children of our counties is $43,813. 2,921 of our cases owe these arrears, so that's a lot of money owed by a few people. There are 1,528 cases paying towards their arrears, so we're collecting about 53% of the arrears that are owed to the children in our counties. In an effort to increase the number of paying cases, we are starting an early intervention program, which has never been seen before. We're trying to contact the non-custodial parents up front, get them to buy in, meet with them, explain the program, work with them to get collectible orders that they can pay and that we can get the money to the kids. Additionally, during the month of August, we are co-partnering with the Department of Motor Vehicles in a program called Back on the Road Again. I did give you each a flyer. There will be flyers up in each Department of Motor Vehicles office, and obligors can contact the office and make payment agreements to get their licenses back. Finally, during the month of August, every Tuesday, we are dedicating to establishing paternity for children who are born outside marriages. They are not automatically assumed to have a father. So the mom and dad can come into our office, sign a form, and it becomes a judgment of paternity that will benefit the child in the future with Social Security, legal matters, etc. I just wanted to let everybody know that our highest goal is to benefit the children of Alpine, Amador, and Calaveras counties by setting collectible child support orders, establishing paternity for the children, and distributing child support funds to the children of our counties. Thank you very much.
Yes, Supervisor Walensky, and before you have a question, I didn't get your name properly.
My name is Marlene Bronner.
Marlene Bronner. Okay,
Yes.
Thank you very much.
Behind the statistics that Marlene brought up, there's an important thing that happened a few years back that I think is a harbinger for things that we need to do in the future. These three counties merged their separate county departments into a single Joint Powers Act agency. This saved a great deal of overhead. That is, administrative costs went down as a percentage of the whole, and that is why this agency has exceeded the state averages and been in the very top few. These rural counties have always lagged, and yet these three have combined to be able to have results that are much greater than any individuals could have done themselves at a lower cost to the taxpayer. There are many other possible joint efforts that we could do with surrounding counties, and this should be seen as a model and a way of creating governmental efficiencies with better service as a result. It's a good combination. And thank you for your hard work. I know the staff really did a lot on this.
We also have them in the CalWorks building.
That's right. We co-housed in places that made for greater efficiency.
It's Marlene.
Where does,
Bonnie?
paternity tax,
Bonnie, if you can come and make your comments at the podium, please.
who pays for the paternity tests and how much are they?
Anybody can come in our office and open a case to establish paternity. The costs are, basically, we cover the cost of the genetic testing, and it's generally about $50 a person, but we have state funding to cover the genetic test costs. So all that would need to happen is someone would need to come into our office, open up a case. They can open a case strictly to establish paternity for their child if they want it, and we will do that.
Thank you. Any other questions or comments? Good morning, Mr. Rusk.
Good morning. You knew I couldn't come 2 weeks in a row and not talk. I couldn't do it. I would mention regarding sound, this mic is difficult to hear sometimes for the audience. This mic is somehow different in sound quality and resonance or something.
Come closer. No, no.
How's this?
You just have to use it like a rock star.
Undecomposed granite. My name is Darrell Rusk. I live at 101 Melcher Lane, Burson. Phone number 772-0225. A few days ago, I was talking with some friends, and one of them said that his 50th anniversary was coming up, and he wanted to do something. And one of the guys asked him what he had done for his 25th anniversary, and he said, well, he took his wife to Arizona, and he was thinking for his 50th that he'd go back and get her. Well, sometimes we have to go back and relook at things. I would like to see a review of the various legal actions involving the county and a review of the specific costs, the potential costs related, what will cover those costs, and whether any of those things that led up to those lawsuits could be reconsidered. If that is possible and doable, it may save the county significant dollars and a great deal of heartache. So there are issues in the legal circuit right now that I think we could take back and pick up from Arizona. Thank you very much.
Thank you very much, Mr. Rusk. Mr. Purley, you look like you're chomping at the bit.
I'm Bill Purley, and I work for Calaveras County Water District. I'm the Director of Utilities, but I'm also Director at San Andreas Sanitary District, and I'm also part of a group amongst City of Angels Camp, San Andreas, and CCWD that are affected by the use of the county's landfill. We received another letter dated July 23rd, 2009, concerning the use of the landfill. Once again, our main issue is that we were under the impression that the supervisor directed staff to set up a meeting with us prior to issuing any more letters out there, and that didn't happen. So what we did was we wrote a response, which, you know, was not a very nice response, but the bottom line is we'd like the supervisors once again to direct staff to meet with the sanitary district, both San Andreas, CCWD, and the City of Angels Camp to work out what type of agreement we need to come up with on the landfill. And that's where we really were coming from. We need a long-term disposal plan. We can't afford a short-term disposal plan. It puts us out of compliance with our state permits. So, I mean, that's basically why I'm here. And we wrote a response, but it was after the fact. So if you guys could do me another favor and tell your staff to set up a meeting with the sanitary district and Angels Camp and CCWD, I'd greatly appreciate it.
Okay, anyone have any questions of Mr. Purley about this?
Not of Mr. Purley, but I'm curious whether a meeting is scheduled. I do believe it was our desire to have people try to work this out.
That was my recollection. Mr. Garcia, do you have any comments about this?
Yes, this letter was written after a meeting with Bill to work out some of the issues that the sanitary districts were having with the disposal of biosolids, and the letter was an attempt to address their issues, and I think we actually did address their issues. What we're doing is correcting an action that was taken by the board, clarifying an action that was taken by the board previously, where the biosolids, if they came up to a certain level of hydrocarbons, we wouldn't take them. What we're doing now is correcting that, what we perceive to be an error, whereas if they come out to a certain parts per million of hydrocarbons, further testing would be required, and a bioassay, and if it was not determined to be hazardous material, we would take them. Now, that was the intent of the letter, and I think that's what the letter stated. And the letter was to address the issues that were brought up by the sanitary districts. In addition, the letter indicated that we would be going back to the council with a proposal stating just what I said, and requested comment from them to address their concerns regarding it. We did get back a letter from the sanitary districts, and quite a letter it was. But we're continuing to work with the sanitary districts. We are setting up a meeting both on the current acceptance policy, the policy we'll be bringing back to the board, and the update to the 5-year countywide integrated waste management plan, which will have to address the biosolids. We'll be coming back probably in the fall for an RFP to go out to do the 5-year update, and that will be the long-term, at least the county's long-term plan for biosolids acceptance policy. So we aren't trying to shut out the sanitary districts. We're trying to work with them. We're trying to address their concerns as soon as we can. We saw this as an opportunity to allay their fears, let them know that we're working with them. Apparently, it didn't quite work out that way, but we continue to work, try to work with them diligently to repair any fences that might have been broken. I'd be glad to answer any questions either of the board or or set up and indicate that we are going to set up meetings with the sanitary districts to go over this.
Okay, well, I didn't see either letter, so I'm kind of working in the dark about this, but I do recall fairly vividly a previous knee-jerk reaction that I thought was quite justified, that we county had issued a letter saying that as of a certain date, we wouldn't be taking anything, and we said, whoa, 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 collectively, we said, no, that's not what we want to see happen. We want to make sure that there is a collaborative effort, no more surprises, no more angst, and what are we going to do with this type of atmosphere? Clearly, that's not happening. So there's a breakdown in communication. But Mr. Purley, do you have some clarifying?
Tom is correct. He met with us on the TPH issue. That was on the screening issue in San Andreas District. We had a bunch of rags and stuff over there that we needed to dispose of, and that's what we worked out with. Our main concern is the long-term sludge disposal. For some reason, they keep, and this is why we hope you guys would make us have another meeting with them on settling the stuff with the sludge. The screening issue was fine. That's what came out in the letter here. We complied with the testing and stuff, and all of our screenings at San Andreas meet requirements, so we can move forward on that. Now we moved on to the sludge disposal issue, which is really what the issue that we'd like you guys' assistance on making sure that thing gets resolved. And that's really where we're coming from right now. But yeah, we did meet on the screenings because they are an immediate problem, and that was fixed. And now we need to move on to the sludge. But we got a letter on the landfill, which kind of indicated that maybe that the landfill wasn't going to be a long-term option for us, and that's really not what we want to happen here. So if we could work out, and maybe communication between Tom and myself and Carol and Steve would probably help that thing out a little bit better.
And that kind of was the intent of the letter, is that the landfill may or may not be a long-term option depending on the results of the 5-year update. The county has to protect its resources as well. And if the 5-year update to the waste management plan indicates that if the 5-year update indicates that it is not in the county's best interest to accept the sludge, then that's kind of what we're going to have to work out with the districts. But again, this is a county document, and we want to work collaboratively with the districts, and we will be setting up meetings to do so.
Well, I'm very tempted to use the phrase that the solution is in dilution. If the fact that the Public Works Department is making a proposed determination or raising the possibility that on some certain date in the future we wouldn't be able to take material that is above a certain parts per million. I mean, I'm just a bricklayer, but I know that if you put twice as much dirt with it before it comes in, you've got half as many parts per million. So please work this situation out. We've got far too much writing on this.
If I remember correctly, it was supposed to have been a temporary solution to go to the landfill. I'm not saying it shouldn't evolve into something else, but when it started, I can't remember.
2001, 2002.
It was temporary. That was agreed to by everyone. And so it's now morphed into something else. And that happens. And I have all confidence that staff in the sanitary districts and the public will work this out.
Well, the resolutions don't say temporary. In fact,
It was temporary. I mean, there was a crisis, and we tried to resolve it.
It wasn't a crisis. We had contracts with private landfills. I'm sorry, but the situation, we had contracts with private landfills, which we terminated to bring those sludge to the county landfill. So our long-term disposal plan, which we are required by law to see the state, was sent to the state saying that we were going to switch from our private landfills, which are still available. All we're hearing right now is we just need to know which direction we're going to go in. If the county is not available to us anymore, fine, then we'll turn around, we'll get a hold of the contract landfills, or we'll come up with some sort of alternate disposal plan. But the original intent was long-term disposal because we had all received notices of violation from the regional board. So we had our long-term contracts which were terminated, and then we went with the county landfill. Now we're being told once again that we're going back to the private people, which is going to cost the ratepayers a whole bunch more money. But that's fine. That's what the direction is.
That is the direction. We hope to work with the sanitary districts to determine what the county's direction will be. And again, our policies will be based on state law, environmental laws, and what we can and can't accept at the landfill. We're trying to protect our assets and not go into violation with the state. And that is what the 5-year update is, just maintaining the county's facilities. And then,
Ratepayers and taxpayers are the same
It's all
ones.
coming out of the same people's pockets, and everybody knows that the school
I'm
rates
sure
are up.
Mr. Garcia
we are
is more
committed to
than
working
willing.
efficiently and with the sanitary districts, and we hope to come to resolutions with this.
Thank you. Any other persons wishing to comment on this? Morning, Mr. Kelly.
Good morning. Joe Kelly. The qualification statement on your Assessment Appeal Board application for appointment is partially correct. What's listed is paragraph 1 of 1624 Revenue and Taxation Code. Paragraph 2 states an additional allowed qualification is a person who the nominating member of the Board of Supervisor has reason to believe is possessed of competent knowledge of property appraisal and taxation. Paragraph 2C, this section shall apply only to an assessment appeals board in a county with a population of less than 200,000. The last hearing on this item, public comment was not allowed, even though changes were made, which changed the dynamics of the hearing, in my opinion, to allow public comment. Had public comment been allowed, the issue of paragraph 2 and 2C would have been brought forward for your enlightenment, disclosure, discussion, and inclusion. The question: will you correct the error before August 24th so those that have paragraph 2 can apply for the position for you folks to consider? Or will it be of an issue here that with the amount of monies being allowed for one of these highly professional qualified persons not come forward? And then you're going to say, we can't get anybody, so we're going to not have an assessment appeals board.
Is anyone else confused about the
No,
question?
I'm not. The assessor's office made it very clear we would be following the revenue and taxation code. The assessor probably didn't list any and all, whatever the revenue and taxation code states in terms of qualification, population size, whatever, will be followed.
Then will you change your application, though, because it only gives one qualification, does not give the second
I haven't
qualification?
seen the application.
Would you like to see it, ma'am?
No, I would not, but I am sure the assessor's office will change it if it needs to be.
Very good, thank you.
Thank you, Mr. Kelly. Anyone else? Good morning, sir.
Morning. My name is Pat Strohmeyer. I live in Hathaway Pines, California. I just came to introduce myself to the board. I am the owner and editor of the Centennial newspaper, which will be starting on September 3rd, which is covering Scenic Highway 4 from Copperopolis to Lake Alpine. I'll leave my card and my flyers here for you if you care to take them.
I heard about that yesterday.
It's going to be
The Sierra Sentinel's back in town.
Yes, I knew Patty Shires from a young man, and I'd like to pick up where she left off. Do you have any other questions for me?
I guess we should notify CCWD.
Yeah, maybe. They already know. I thank you for your time.
Good morning. My name's Bonnie Newman. I'm from Double Springs. Something happened here in the boardroom a couple weeks ago that it's taken me 2 weeks to process, and I'm having a real hard time understanding. I have a question. What happened to Gary Kuntz? I mean, the sheriff got up here and he said those guys are going to be gone, and I think he's gone. There was no thank you. There was no handshaking. There was no round of applause for all the years that that person put in our county. I was in shock. I couldn't say anything. I had to block it out. I couldn't believe that our sheriff would treat someone that way after 27 years. I'm still in shock. What happened? Initially I thought that it was to punish you guys and to humiliate you. Then I felt pain and humiliation for Gary. I mean, I'm just disgusted by what happened. I have a thank you card for Gary for all the times that he helped me with the crisis line and with my ex-convicts out on Double Springs Road. I don't know what to do with it. He's not in the phone book. I can't call. Doesn't have an address. With the way that he was treated, I'm afraid to give it to the sheriff's department because I'm not sure he's going to get it. I'm just appalled at how that whole thing was handled. I saw the cook get hugs and kisses for cooking at the sheriff's department. I saw nothing for those two gentlemen that we were told had lost their jobs. 20 years, 27 years. Has anyone heard from Gary Kuntz since he left? Because I'll tell you what, I only worked women's crisis 13 years, but when my job was yanked out from under me, first thing I wanted to do is jump off the bridge. Well, I don't know if he's prepared for not going to work every day after 27 years, but I think someone should reach out to this guy. And I want to give him a thank you card, and I'd like to shake his hand.
Bonnie?
Bonnie?
There,
Can you give the card to Madeline, and I will make sure that Gary gets it?
is there anyone else wishing to address the board this morning? Morning, Sheriff Downham.
Good morning, Dennis Downham, Sheriff. I don't even know if it's appropriate to discuss any kind of personnel actions here, but Bonnie brought up something that probably does need to be addressed. There wasn't any hugs, congratulations, or retirement party or anything else because it's not done yet. We don't know what action the board is going to take this afternoon. We don't know what's going to transpire by final budget. Gary is very, very well aware that if something happens by final budget, the money's forthcoming or whatever, he comes back. It got down to imagine a situation where we were able to save the senior lieutenant. We weren't able to save the other one. Gary's on hold, and once that decision is finalized, then we'll do what's appropriate. But at this point, he is laid off. Whether it's going to be permanent, we'll know by final budget. Thank you.
Thank you for that clarification. Anyone else wishing to address the board this morning on items not on the agenda? Okay, seeing no one jumping forward, let's go to item number 6. This is a public hearing and possible board action regarding, this is 2006 143A, a zoning amendment for Louise Spence and all. Would you please give us an explanation, Shailene?
Good morning, Shailene Stratton, Planning Department. This is a zoning amendment to rezone approximately 3/100ths of an acre to accommodate a boundary line adjustment, which was a response to a required mitigation on a subdivision map that was approved in 2007. The Planning Department staff has no objections to this, and it was recommendations for approval by the board was passed by the Planning Commission in May of this year, and there's a copy of that resolution in your packet.
Any questions of Ms. Stratton? It's in Tom's district. Well, if nobody else has any questions, I do have a couple. Okay. This is just one small typographical error in this thing. It's alternately listed as 3/100ths of an acre, and then on another page, 3/10 of an acre. But nonetheless, this looks like it's a sliver of land that's at its widest point is 6 feet wide, going down in about 1,200 feet to nothing. And I see that the application on this goes way back to 2006. Is it usual and customary for us to be seeing something like this 3 years later after the application?
This is part of the cleanup that we are doing in moving our projects forward. This is one that probably should have been taken care of some time ago, but it's something that is still pending and needs to be taken care of at this point.
Okay. Anyone else wishing to make a comment on this this application or this particular item? Any questions of Shaylin? Okay, I'd like to close the public hearing and ask the board for recommendation or comments.
I would move the item, Mr. Chair, 2006-143A zoning amendment for Louise Spence et al. This is categorically exempt, I believe. So that's the motion.
Second.
Moved and seconded for approval. All in favor say aye.
Aye.
Aye. Opposed? Hearing none. It passes unanimously. Thank you. Okay, the next item, this is a discussion and possible action regarding a minute order authorizing the board chair to sign a certificate of acceptance of a grant of easement preserving 197.2 plus or minus acres owned by Gerald Dunn. Comes also from planning.
Deborah Lewis, Planner 3. In this project, the Planning Commission approved project 2007-045 for a tentative parcel map for Gerald Dunn back in June of 2008. He was proposing to divide 502 acres under Williamson Act contract into two parcels of 305 acres and 197 acres. One of the conditions of approval that was attached to that parcel map was that he provide documentation to the county that the 197-acre parcel be protected in perpetuity by a conservation easement prior to recordation of his final map. The applicant attempted but was unable to initiate a conservation easement in partnership with the California Department of Fish and Game, which was his original intention. Although the property was accepted for the Fish and Game program and the applicant met all of the Fish and Game requirements, reductions in the state budget that funds the conservation easement program resulted in a curtailment of the conservation easement process. As a result, the applicant was unable to meet the requirements of this particular condition of approval and proceed with recordation of his final map. So the grant of restrictive easement that you see before you now is the functional equivalent of that conservation easement and was developed, the county working in consultation with the applicant to arrive at this solution. I would like to draw your attention to two sections in the grant of restrictive easement. Section 10 identifies a process by which this easement may be vacated in future if that is something that the applicant chooses. Section 11 of this agreement allows for this grant of restrictive easement to be superseded in future with a comparable agreement with the with the California Department of Fish and Game at the time that they are able to execute their conservation easement with the applicant.
You're saying that this, what number were you, what was your second number that you're?
11.
Section 11?
That means that this condition then will become null and void as far as the county is concerned?
This grant of restrictive easement will become null and void in favor of a comparable agreement with Fish and Game, yes.
Okay, but if they don't get the Fish and Game?
This will remain in effect.
This will remain in effect.
And I refer you back to Section 10, if in future the applicant decides to go forward with a different sort of agreement, he has the option to return back to the board and negotiate something different.
Any other questions?
I have some questions, or big questions. I'm a big fan of the Williamson Act, which is a 10-year restriction. We have a grassland conservancy, which is I think can go up to 30 years. Most of them are 20-year restrictions. We have a Super Williamson Act. I want to say it's either a 20 or a 30-year restriction. If you go to the first paragraph here, it basically says that this is in gross for the property, a perpetual and irrevocable restrictive easement over the subject property. I personally have a very difficult time with the concept of perpetuity and having something be irrevocable in perpetuity. If you look at economics and you were in an economics class and said, geez, I'm all for irrevocable conditions in perpetuity, you would get an F minus, because the whole basis of economics is moving resources around constantly to meet the highest and best returns. A lot of times we reduce capital gains cap rates and land as a capital. It's because we want to realign resources so that we can maximize returns from resources. So this whole concept of perpetuity on an economic front is nonsensical. If you look at it from just a human point of view, the concept of perpetuity, in my opinion, is sort of the ultimate in human arrogance, that we can sit here and decide, what's in the best interest, what the best allocation of resources is, what the demographics, technology changes will be 50 years from now, or 100 years from now, or 200 years from now, or 1,000 years from now. I mean, we might as well be building pyramids for perpetual life hereafter. So the concept of perpetuity and sort of irrevocable covenants in perpetuity, to me, I find very offensive, and I find to be absolutely nonsensical as to what are we doing here. We can do things over time that provide for an orderly structuring of resources, and my earlier examples of a grassland conservancy or a Williamson Act, Super Williamson Act, et cetera, I think meets those because they're not in perpetuity, and you have a chance over time to reallocate the resources. So the concept of perpetuity, irrevocable covenants in perpetuity, to me is something I have a very difficult time supporting. Having said that, it basically says in paragraph 1 that this is perpetual, irrevocable in perpetuity, and then you basically go to paragraph 10 and say, oh, the grantor can vacate this easement. I don't see how the two are consistent. And I think if you went before a judge, the judge is going to say, because code says for a state code for an easement that it has to be irrevocable and in perpetuity. So I don't know how we can put a paragraph in number 10 basically saying that the grantor can vacate this easement. How can it be both ways?
These are standard terms of an agreement. What I see Section 10 as stating is that, as you had said, he has the option to reconsider economic conditions and use of assets and bring forward another proposal. He will be subject to entitlements, specific approvals, and conditions of approvals to be imposed on any changes he would like to make to this agreement. I see this section as allowing him to simply renegotiate an agreement to more favorable terms in future as economic conditions change.
Well, then it's not irrevocable in perpetuity. I mean, it can't be both.
That is correct.
Quite frankly, I think if you ended up in a court of law, and this is done according to statute, that you're stuck with irrevocable in perpetuity, not grant the grantor's right to vacate the easement or to modify the easement, even though he wouldn't meet the new development standards of the time. I mean, the Williamson Act at least says you have to be in for 10 years. This doesn't even say that. This basically says the grantor can come in at any time a year from now and say, I want to vacate the easement or I want to change the easement, even though I will have to meet the current development standards. So I have a very difficult time looking at this easement and understanding where exactly this is taking us. It seems to me that you know, and we have the Williamson Act, which allows exactly that to happen with a 9-year or 10-year lapse, depending on when he would file for
non-renewal.
For non-renewal. So I question the validity of what's before us. And as I stated, you know, the concept of irrevocable in perpetuity is just, in my opinion, an absurdity. So those are my comments.
Comment noted. I would also like to add that this agreement was developed by County Council, so it wasn't something that came from the Planning Department.
I spoke to Janice about it earlier this morning, expressed the same opinion.
I'd point out that an easement, the typical easement, is in perpetuity and irrevocable, but it can be abandoned by agreement between the grantor and the grantee. So I would suggest that they're not really irreconcilable.
When the grantee is the government, as opposed to an easement between two private parties, when the grantee is the government, then you just fill this boardroom up with all the neighbors that have now built up around this, and this is our open space, and this is this, and this is that, and just try to get it changed.
As she said, comment noted.
Through this process, as opposed
Tom,
to
we have road
two private
easements,
parties
we have
that are
utility
abandoning an
easements.
easement. That's not, to me, the difference between day and night.
Is the owner here, Mr. Dunn?
Yes.
Okay. Anybody have any questions of Mr. Dunn's intent here? Supervisor Walensky.
I actually don't have any questions because Mr. Dunn and I have been working together for years on this effort, and his patience working with the Department of Fish and Game is really legion and almost superhuman. This represents an alternative, and I do appreciate the county stepping up. Mr. Dunn's property, if anybody wants to see what good land stewardship is, they ought to go take a visit to this place. It is one of the great working cattle ranches in Calaveras County. It is absolutely drop-dead gorgeous, and it represents a tremendous amount of hard work by this family and preceding owners. The situation before us is presented as a life goal and wish of the Dunn family. It is an expression of their property rights. And it seems to me inappropriate for government to alter or tinker with the wishes, which I view as not whimsical, but long-term and heartfelt. There may be different ideas of what higher land use might be, but it would be hard to argue in the country that built the first national parks that there shouldn't be some portion of Calaveras County, especially its most wonderful portions, that shouldn't be set aside for future generations. My hat's off to Mr. Dunn. I know that when he first put much other acreage of this ranch into conservation easements, I know he took a lot of flack for it, and that was hurtful, and he expressed this to me a number of times. I'd like to reverse that and thank you for your commitment to the future, for your commitment to the land, to your spectacular stewardship, and your willingness to take this action. Yes, of course.
Of course.
My name is Gerald Dunn. To address Mr. Tryon's concern, I was an economics major at Davis, University of California. I'm well aware of the issue in your mind. But I think there's time you have to separate ideology from economics, and that's what this is about. Does that make sense?
No, and let me answer it. I mean, there isn't, if you wish to preserve your ranch, and I understand that it's a very well-managed ranch, it's a beautiful ranch, et cetera, you can do that as the property owner. You don't have to give up a significant amount of control or degree of the property right, which is use, control, and disposal, and you're maintaining use, at least limited use, as a cattle operation. But the other two, you're basically giving up to government. And you know, if you're coming with an altruistic, which I believe you are, approach about, well, I wish to preserve this, and like, you can do that in the private sector, and you can do it within your family without including government. I don't see what government brings to the table other than if you get on with Fish and Game, most of these land easements bring a fair amount of money from the government sector. So it really it's a purchasing of two aspects of the property right, basically control and disposal, basically gets transferred to the government while a restricted use remains with the property owner. And I would question whether that's good public policy, because you can do that in the private sector. It's not like we don't have the government owning enough land in California or in the West, particularly, where, you know, some states it's 90% owned by government. It seems to me we have a more public interest in preserving the private property right than we do transferring more of that right to government. The other part I always find that I tend to think is somewhat in conflict is the more we divide the property right, whether it be surface, you know, mining rights, which are subsurface, you have use, somebody has other control and disposal, it gets to be more and more difficult to sort of manage land in a coherent fashion. The more we just, you know, just keep carving up property rights. So, you know, I always think the best property and the property that's easiest to manage is that which is owned in fee, simple, absolute, as title. And the more we move away from that, the more difficult it is to manage. So I guess I don't see the public purpose in having government involved or government paying for these conservation easements, because if it's not being done on the basis of money, you can certainly do that in the private sector. You don't need government as a vehicle to accomplish your goals.
Well, again, back to the concept of private property rights, I am a proponent, strong proponent of private property rights. Mr. Walensky mentioned that this is, at this point in time, within my rights as a private property owner. The concept of perpetuity, to me, is essential. Because while I own the property today, the facts of life are I probably won't be here in 25 or 30 years. Someone else will take it over, either an heir or an outside party. My private property right today is to keep that property in as pristine a condition as possible in perpetuity. I'd like to exercise that right. Recognizing that economically it seems foolish to some.
I guess my response to that is I would not grant you that. property right. The idea that you own the property after you're dead, and that you can somehow, and that's what I think in a lot of ways is perpetuity is, it's just what you say. You want something to go beyond your life.
That's correct.
I don't think it's a particularly good public policy to say that people can, basically control the property in perpetuity beyond their life.
Teddy Roosevelt did real well with it.
Well, Teddy Roosevelt did the national parks, which were government land.
Correct.
And government land's different than private land, so I would say you have a huge distinction there.
If I sold an easement to PG&E, that would be in perpetuity.
Yes, but if PG&E and you wanted to change that easement, you could do so without the involvement of government.
Perhaps.
You don't have to come to a public hearing. You don't have to do a CEQA review. You don't have all the neighbors show up. I mean, when you put it in government, you change the whole character as opposed to two private parties.
Still private property. It just has restrictions. Zoning restricts all land.
Yes, but it's not in perpetuity. We change zoning all the time.
That's my position.
Yeah, I understand that's your
Appreciate
position.
your
But I think as public policy, that's not the public policy position for government.
Mr. Dunn, there may be other questions. Please don't go away just yet. Supervisor Walensky.
I just wanted to make one further comment, which is that we are lucky to live in a country in which people can define best uses and exercise their rights in a variety of different choices. This is one. It's not the only one. Some people may think it's not the best one, but the right of the individual to keep faith with his beliefs, core values, and sometimes their faith specifically being the guide. That ability to exercise that is one of our fundamental principles in this country, and I think the exercise of it in this case is both appropriate and laudable.
Any other questions? Mr. Clapp, yes.
I agree with Tom in a lot of ways because, a lot of old deeds and stuff with CCs and Rs that you couldn't sell to black people, Chinese people. Now, the courts ruled those wrong, but those are still stuck with it. And when President Nixon ran for president, it came up that he had a piece of property that the CCs and Rs you couldn't have the black people. So I understand what Tom's saying. You're encumbering property with stuff that may later on be ruled illegal or something like that. So I understand what Tom's saying. You're encumbering property with stuff that could be illegal later on.
That's not what I was saying, but that is the point. Mine was more on economics and property rights than cultural restrictions.
Okay, any other questions or comments? Mr. Dunn, from me to you, thank you very much for your efforts here. I applaud what you're trying to do. It's paradoxical that we have two people with degrees in economics at odds on a philosophy of what a person can do with his own property. I think in CEQA law it requires that we do an EIR when we have disputes among experts. So that's just a little joke, a sick joke. But anyway, thank you very much. And the chair entertains. Well, I'll close the public hearing and bring it back for a possible motion.
Yes, Mr. Chair, I would like to move that the Board of Supervisors approve a minute order authorizing the board chair to sign a certificate of acceptance of a grant of restrictive easement protecting the agricultural, natural resource, and open space values of this 197.2-acre parcel of agricultural preserve lands owned by Gerald Dunn.
Second.
Okay, moved and second.
I have one additional comment. I just want to be very clear, because Russ's comments just before the motion do not reflect my view. And this is not about what Mr. Dunn can do with his private property vis-a-vis other private entities. When what you do with your property is you take it to government and you receive compensation for your property. then as soon as government's involved, it's not so much, to me, then it becomes a public policy issue. I mean, I'm not in favor of this, and my tax dollars are going to buy this easement. Other people are in favor of it, and their tax dollars are. But once government is involved, then I don't think you have a pure, oh, he wants to do it, it's his property, it's his private property, he can do what he wants with it. Well, when it comes to government, it's all of our money, and we have a right to state what is, in our opinion, is the appropriate public policy involved, as opposed to Mr. Dunn going to the Nature Conservancy, for instance, as a private nonprofit, and saying, I'll give you my property, and it's outside of government. Once you come to government, then I think you set a different standard, particularly when government money is being utilized to purchase an easement. It isn't in front of the county, but it will be in front of Fish and Game, I believe.
I think it's really important to restate the obvious here. There is no county financing. There is no financing. This is not a financial transaction. This is not even, in Mr. Dunn's perspective, a financial transaction. That is not the highest principle that he is expressing in his life. He's made other decisions, and he's decided to do this. This is not about county money or anybody else's money. He doesn't seek any money. He simply seeks the legacy that he's proposing here. That's we're really mixing different kinds of priorities, but he is not asking for one penny, and our board packet says under financing, it's the shortest financing description yet in any packet I've seen. It says none. Good enough for me, and I reiterate my motion.
Okay, we have a motion and a second. All in favor say aye.
Aye.
Aye. Opposed?
No.
Okay, let the record show that the motion passes on a 4-1 dissenting. Okay, we have item number 8 now. This is a discussion of possible action regarding the adoption of an ordinance amending sections. I'm going to just kind of gloss over this. This is regarding the housekeeping that we have to do to remove references to the Community Development Agency and or the Community Development Director from our codes and county documents.
I move adoption, waive reading.
We have a motion?
Second.
Okay, moved and seconded to approve this item. All in favor say aye.
Aye.
Aye. Opposed? Good job, Chris. All right, going on to item number 9. This is a discussion, possible action regarding the resolution authorizing a contract for law enforcement services between Calaveras County Sheriff's Department and the Couts Ironstone Vineyard. Good morning, Under Sheriff Walker.
Good morning, Michael Walker, Under Sheriff. This contract actually is the second contract that we have done with Couts Ironstone Vineyards. The first contract has expired. This contract has built into it an ongoing clause. It'll go year to year, subject to termination by either party 60 days prior to the start of the concert series. It also has in it an escalator for the monetary compensation to the Sheriff's Office by Couts for the Sheriff's Office to provide the deputies to the concerts.
Any questions of Under Sheriff Walker?
Also move, Mr. Chair.
I'll second.
Okay, moved and seconded on discussion. Were you there undercover on Saturday night?
I was there enjoying myself.
Okay, had nothing to do with this
Were
contract.
you dancing?
No.
No, I wasn't.
Were you singing?
I may have done that.
I saw him singing. All right, we have a motion and a second. All in favor say aye.
Aye.
Aye. Opposed? Motion carries unanimously. Thank you. Okay, we have item number 10 now. This is back on the agenda, and the judge and the representative of the courts is here. This is a discussion and possible action regarding approving additional terms for the agreement to transfer approximately 7 acres to the administrative office of the courts. for the purpose of the courthouse construction. This was continued from 7/7 and 8/04/2009. Okay, do we have any discussion on this?
Well, this is, I think, the fourth time this has been before you. The agreement to transfer the property to the AOC for the court was actually approved by this board, I think, early in July. We thought at that time that we had a deal. AOC then worked with the State Public Works Board staff. They were directed, I suppose, to put some additional provisions in the agreement. One of those provisions, for example, would have required the county to reimburse the AOC for its various planning and pre-construction costs if the county was, for example, unable to obtain the wetlands clearance that is an issue with the property. So those and some other additional requests were brought before you. The board didn't vote, but you did clearly, on a poll, reject those changes. We had further discussions, and finally, I think those changes have been withdrawn. There was another provision that would have allowed. This agreement requires that the county will make certain improvements to Government Center Road out here, and bring it up to county standards. One of the requested changes had been that if for some reason the county failed to do that the AOC could do it and charge the county. That provision has been changed, and to say that if in the event that the AOC for some reason has to step in and make those changes, the AOC could reimburse itself out of money that the AOC owes the county. That money is $200,000, which you've loaned to the AOC for the sanitary district. So that convoluted process, they would be able to take a credit for that money. So that provision has been limited in that way. Then last week I reported to you that we had requested some language be inserted in the document that made it clear that the county reserved the right, as the evidence unfolded, to revisit and possibly amend the mitigation measures. This relates primarily to, I think, a belief that perhaps the traffic studies, the traffic mitigations may be adjustable to some extent at a savings to the county. So the AOC agreed to that language, and we're pretty much back, I think, to the basic agreement that this board approved a couple of months ago. And it's here before you. I'm recommending that you approve the agreement, primarily, as I mentioned in the board memo, that if you don't, that would pretty much be the end of the courthouse project for the foreseeable future. And I think it's a reasonable agreement. I've discussed several times the obligations that the county has undertaken by accepting this agreement and the benefits that we receive. There's been no way to measure those numerically, but I think the board has clearly indicated that this is something. This is a county goal to make sure that the court facility is located next to the new jail facility. I've talked with the CAO. I think he supports the agreement as well, and so I'm prepared to. Oh, and Lee Roberts from the AOC is here. I appreciate that. He can answer any questions that you may have, as well as Judge Mawini. And I'm prepared to entertain any questions.
Any questions of the county council?
Yeah, I do on traffic. Mr. Jones, I'm not really clear. I heard what you said, but I'm not clear what that means. Because the traffic for the jail could be, we know the traffic study doesn't need, exceeds what it is that our needs are going to be. But the traffic for the jail is going to be substantially less than the traffic probably for the courts. So I'm not clear what it is that has to be done, who has to do what, and how will it be paid for or compensated.
Well, all of that is spelled out in the study that was done that was the basis for the mitigated negative deck that the board approved. I'm not so sure that there were certain assumptions made about the increase in traffic presented by both facilities. I'm not intimately familiar with the details of this traffic study. I think actually the result was the opposite of what you suggested, that the added impact by the court would be relatively would be a fraction of that of the added by the jail.
So there'll be more people going to the jail than going to the court?
Well, more added people because of the increase in the size of the jail. Yes, but it's not really my goal wasn't to discuss the traffic so much. That's all done and fixed and behind us. The discussion, the current discussion, and the discussion that we want to possibly revisit in the future has to do with some of the assumptions that went into that traffic study. If it turns out that, for example, the projections of increased traffic by the jail facility are less than what was assumed in that study,
right,
we wanted to just simply reserve the right to amend the mitigation measure accordingly, and this document preserves that right. Janice may have something to add to this.
Janice Elliott, County Council. Just to clarify, the traffic study for the mitigated neg deck was based on the traffic study that Public Works was doing for the proposed San Andreas Benefit Basin study. It was primarily based on ITE trip generation rates out of those journals. The conditions of approval and the mitigation measures are all based on the traffic study, but there's also a level of service issue based on our general plan language. What we're looking at now, or what Public Works is currently looking at with respect to the traffic study, is whether or not we can use more site-specific assumptions as opposed to ITE traffic assumptions. I'm not saying that anything's going to change at this point because they have not given us an opinion, but I was just wanted some language in here to make it clear that under CEQA we can go back and amend, delete, or modify mitigation measures based on substantial evidence in the record. And that language is now in there.
Okay, so while you're here, or Mr. Jones, on 7.3, the seasonal wetland environmental clearance.
Right. Let me clarify that also based on some past discussions by the board. The current mitigated neg deck already requires, under mitigation measure bio-5, that the county shall do a wetlands delineation and have it verified by the Corps of Engineers. That's been in there since you certified this mitigated neg deck. All the work that's being done by Art and his sub-consultants is done in compliance with this mitigation measure. I don't anticipate any changes to this mitigation measure because we are doing exactly what it requires us to do. And we do have an opinion from the consultant at this point, and we need to move forward on that opinion and do what's required by the mitigation measure.
Okay, and the courts will not hold us up, I mean that literally, on paying for any impacts to environmental issues on the court's property other than what has been agreed to a cap of the $200,000.
Under the agreement, the court has to comply with all of the mitigation measures in the mitigated neg deck with respect to their property. It's their responsibility.
Their responsibility.
Except for the wetlands delineation. It
Right.
made more sense to do that over the entire project. So what the agreement currently says is that if the responsibilities that are delineated in there by the county are not done by the time, what is it, time of construction start? I don't remember the terminology.
Start date.
That with respect to this road, and there are traffic mitigations for the Government Center Road to bring it up to the current county road standards, that they can go ahead and construct that, and that Public Works will issue them the necessary permits and approvals to do that, and the reasonable cost of doing that will be credited against the $200,000 loan that Mr. Jones discussed.
Okay, so consulting with the proposed mitigation measures with the AOC does not commit us to anything except to include them in terms of information.
I'm not sure I understand your question.
Okay, I have to use this word because I love it, the penultimate sentence. On an ongoing basis, county will consult with the AOC and its consultants with respect to any proposed mitigation measures with respect to the real property. Doesn't mean we have to, I mean, I just see us being, no offense, AOC, Judge, being manipulated somehow, that they don't quite like what it is we're saying, or they want to massage it. And then all of a sudden, we're paying for something we shouldn't have.
No, I think that language is in there because I believe everybody agrees there's sort of an economy of scale in complying with the mitigation measures. For example, if everyone's going to grade at the same time, we'll comply with the grading mitigation measures. And it's just an example of the parties consulting with each other with respect to compliance.
No, I think I like the idea. I mean, I think it's appropriate that we do that. I'm just concerned about getting stuck, changing things and getting stuck with the bill.
The AOC is a responsible agency under CEQA. And under CEQA, they are limited by statute as to what actions they can take. Their intent is to adopt this mitigated neg declaration as it currently stands.
Supervisor Walensky?
County Council suggested that the demands that appeared before us and resulted in a recommendation to reject previous iterations of this have disappeared, essentially. I'm curious about the nature of that. Is that assurances that we have from the California Department of Finance or Department of Public Works that this document that's before us today would be acceptable, or are we simply agreeing on the areas that we locally can agree on and hoping for the best at the state level?
I've learned I would not bring this to you today were it not for an email message that I got from Mr. Roberts, I think, on Friday, telling me that the Public Works staff had approved this document. I think that means that they believe that this will go on the consent agenda for the Public Works Board.
Right. That's what I was looking for.
Which is probably about as predictable as what this board might do, but gives a high level of confidence, I think. That
surely they must be more predictable than we.
I think that we have about as much assurance as we can have that this will be acceptable. But Lee, you should stand up here and go on the record.
Yeah, I'd encourage that as well.
Good morning, Lee Roberts with the Administrative Office of the Courts. And Mr. Jones is correct. We have gotten as straightforward an assurance from Public Works Board staff that this agreement, if approved here today by the board, will it is currently on the consent agenda and would pass with all the other items that are on there without further scrutiny.
I did have one further question. Do you have something you wanted to add to that?
Oh, I just maybe technical point that we don't yet. We're still trying to assemble some of the exhibits, so I still don't have the complete contract. I won't be asking the board chair to sign this right away, but because we need to attach a few more of the exhibits.
Are you looking for an action today?
I am, yes.
My other question had to do with the memo that we got from the consultant using a term that I had not really heard before, and I'm wondering whether somebody can explain it a little bit further to me. It's called a nationwide permit. Deals with wetland incursion of under 0.5 acre.
I think
how does that work, and do we have any experience with it?
Art probably is the best. Art or Janice, I'm sure, can elaborate on that.
Art Lytle, Senior Project Manager with Kitchell. It is my understanding that with the size of wetlands that EDOF feels we have, that the permit with the that will be required will be a simple, straightforward permit. It's not going through the long, drawn-out process that you go through the nationwide permitting. Until their report is finished, which may be another 2 weeks before we have their final report, this is the best direction they could give us. So, I don't know if that answers what you were looking for. But
Well, I guess we have more to know about it yet.
I do know that they went out and they did a lot of testing and checking to see if we have all the little creatures that we're supposed to have for vernal pools and plants and soils, and that was not found to be existent. So I think we're in much better shape than we were before with the previous information. But it remains to see what comes out in their final report.
Any other questions?
Let me just supplement that. To make a very complicated subject very simple, there's basically two types of permitting through the Corps of Engineers. What Art's talking about is called the nationwide Section 404 permit, which is basically a permit that has standard mitigation measures, conditions of approval in it that applies pretty much broadly, as opposed to a site-specific, which I believe is called the Section 401 permit, which requires a lot more work and time. So basically, all you need to do is submit your wetlands delineation to the Corps, have it verified. If they agree with you, then you just comply with the standard conditions and mitigation measures. So it's a much simpler process. And to be honest with you, I've anticipated that would be the result from day one. So I'm not surprised by this at all.
All right, thanks. That's actually the answer I was looking for.
Any other questions? I just have just a couple. Assuming that we will approve this, the transfer of the title will take place in 30 days or due course?
In the near future, yes.
Okay. All right. And as I read this under 7.6.2, all of the biological requirements related to the dealing with the shafts, the mining shafts, the removal and possible replacement mitigation measures for oak trees, that's on the court's nickel, not ours.
To the extent, if it's on the court's property, yes.
Yes.
What will become the court property, yes.
Okay.
And the court loves oak trees.
All right, Mr. or Supervisor Walensky.
If there are no other comments, I would move to direct the board chair to sign the agreement to exchange interest in real property, the document that is before us today.
Well, as potentially amended and as recommended by county council.
That's correct.
Yeah, the document before you refers to all of the exhibits. They just need to be
Just be clear that
attached. Yes.
we want, at least I want your concurrence before the board chair signs something.
Yes.
All right. That's a friendly amendment.
I'll second it then.
Okay, moved and seconded. All in favor say aye.
Aye.
Aye. Opposed? Hearing none, the motion passes unanimously.
If it's not too late, may I just say a word? And I want to just thank the Board of Supervisors for their very careful and thorough and patient work on this matter. And we at the AOC very much look forward to getting this project in the ground and providing this service to the people of Calaveras County. And we're very excited about this and very grateful for your approval today.
Thank you, Mr. Roberts. Okay, moving on to board matters, review of correspondence, reports, and various matters of concern. Could we start this morning with Supervisor Tryon?
Let me think. I think I have a Lodging Association annual dinner at Utica Park and Angels on Wednesday.
Okay, is that the extent of it?
That's it.
Okay. All right, Supervisor Walensky?
I believe the only board thing would be, I understand the Chamber of Commerce is holding the economic forum on Friday. Has that not, have they not put that out?
I haven't seen
In that case, it
anything.
may have been, maybe in my calendar, but may have moved back. I'll be there if it exists and not if it doesn't.
I haven't seen
I haven't seen it either.
Well, I guess I'll make a call down there and find out.
There is a campaign going on, so they have been
It might have been
distracted.
put off.
So. Does that conclude your report?
That concludes my report. I got a lot of other meetings, but no board
That's
assignments.
that's an all-time, that's a record.
Whoa.
That is. That is a record. I'm shocked.
Yeah.
I'm sure I'm leaving something out, but it's not in the calendar.
Supervisor Toffenelli.
I'll be at the Visitor Bureau's barbecue at Utica Park on Wednesday also. I will be at the American Legion Ambulance annual meeting in Sutter Creek on Thursday. And that's all I have. I did go shooting with Mr. Jones last Thursday.
They call it shooting, not hitting.
And at the Comanche, what was it? Comanche
Comanche Hills Hunting Preserve, yes.
Yeah, we were shooting sporting clays, and I'm here to tell you, I hit some, but there's a lot of dead air out there. I hit a lot of air. And you know, I was telling Jim that Bob Euchre had a euphemism for catching a knuckleball. He said the best way to catch is wait till it stops rolling and walk over and pick it up. The same way with sporting clays, the best way to hit them is wait till they land on the ground, walk over and shoot them.
That's good. I like that.
So that's it for me.
Supervisor Calamay.
I'll also be at the Visitors Bureau function tomorrow night. I'll be in Sacramento on Thursday for the state water plan, and I'll come back to Friday in a moment. And on Saturday at Cedar Center in Arnold, the Humane Society is having a fundraiser. It'd be nice if I would see all of you up there. On Friday from 10 to 11, there's a conference call regarding the Williamson Act. And if you, that's being sponsored by CSAC with the state. Mary Muntz, our Ag Commissioner, is going to be on the conference call. And if you're interested in participating, please let me know and I'll give you the number. I have to let CSAC know if you want to participate. It'll be from 10 to 11 on Friday, since the Williamson Act seems to be in flux. And that's all I have. Oh, no. Two things. Area 12 Agency on Aging, because of funding, has done a layoff of 4 people. And they also might not need to borrow the funds that this board approved. I do want to thank you for supporting the borrowing. They will let us know if they need it, but if the state comes through with the funding, they will not be borrowing the money. Calaveras Public Power Agency has, Bob and I met with them, and the energy consultant who did the preliminary phase 1 and 2 of the county energy audit. We have as you know, I'm your board representative on Calaveras Public Power. We have 3 programs. We have a $1,000 grant we just gave. You want to change light bulbs out. We have instituted a grant program of $50,000 with a maximum loan to one of the agencies of up to $10,000. It's grant only, and there's also the loan. So there's really no reason for us not to be doing energy conservation programs. And we have asked, Bob, we asked them to submit a Phase 3 audit. It does commit us to $25,000, but we have asked that, which is based on energy savings and their preliminary estimate. If we proceed and we get the grant, they will be paid out of the grant, but which we think we can be able to do that, but we're on the hook for $25,000 to do Phase 3 of the energy audit. Am I right on that, Mr. Lawton?
That's correct, although the grant, if and when awarded, that $25,000 would be first instance money out of the grant, which is incidentally not a competitive grant, but rather a formula grant,
Right.
to which we would be entitled.
And it's money from the federal government to the state, to us. On a lighter note, I want to remind everyone, if you're going to be awake at 10:30 to 11:30 tonight, there's a meteorite shower.
A lighter note?
But
On a lighter note.
only if you have a dark sky.
Well, I want to talk about dark sky. I've got this ordinance sitting on the back burner I'd love to get approved. So sit on your deck with somebody that you enjoy and watch the meteor shower.
It's 10:30?
Well, we're probably about 11, but you want to go earlier to get your eyes adjusted to the dark. You do not need binoculars or telescopes. You'll be able to see it with your naked eye.
And when is it? What
Tonight.
night? Tonight. Okay. And you mentioned something earlier on a Friday event that we should all attend.
If you're, no, it's
Oh,
if you're
sorry.
interested in the Calaveras Humane Society's having a fundraiser at Cedar Center in Arnold.
That is on Saturday.
Saturday.
Starting at what time?
About 11 o'clock to about 8 p.m. It's wine and art and dogs and cats.
All right.
Trees?
And trees.
All right, that leaves me here to make a report. Board responsibilities this week are light as far as committees and stuff, but I will be attending the Mountain Counties Water Resources meeting at La Contenta at 9 o'clock on Friday. This is being conducted, I think, at La Contenta, maybe largely due to the fact that Bertha Underhill is going to be going out as the chair of the Mountain Counties group, and apparently there are some weighty issues that will be discussed regarding water rights and the possibility of some grabs on our water allocations. So I'm sure that they would enjoy participation of any other board members who would like to go. You should contact, if you're interested in going, you should contact Mona Walker over at CCWD. All right. And Supervisor Toffanelli, I left a message for you about a time conflict that I'm anticipating for next Wednesday about the Cosgrove Creek.
Is that Wednesday or Thursday?
I've got it on my calendar that it's a Cosgrove Creek meeting at conference room at CCWD. But there's also a...
Well, that's at 1 o'clock.
Yes.
I have a meeting in Bear Valley at 10. I'm speaking at 12 at New Hogan, and I'll be at CCWD at 1.
Dear Lucas, if we carry.
So So
10? Are you doing a
I'm
drive-by in Bear?
That's gonna be a rough day.
Are you getting a helicopter?
I'm asking Mr. Jones to fire up his plane and
Do a drop.
There is an airport in Bear Valley.
There is,
Not-
it's a private airport.
Yes, if you
We
would
can
like
arrange-
to land,
We can arrange a parachute.
I can,
I wouldn't recommend it in
I
a
was watching a
182.
plane trying to land there.
that's
Couple
next
weeks
week.
ago.
And I was going to ask for some help.
You talked about
Schedule conflict.
at Hogan, but you're also on the agenda for the Area Business Association Valley Springs.
That's at New Hogan.
Oh, it is?
Yeah, it's
Oh,
the
that's
luncheon
it.
at the Overlook.
Overlook, okay, yeah, I was thinking, all right, you're right.
I am the featured speaker there that day, so. Are you
Can I have
offering to
your
go to Bear
autograph?
Valley, or are you going, are you
I
going
have
there,
a
or are you-
10, I have a 10 to 1:30 conference call, executive committee meeting, which I can't go to because we have no money in our budget
Well,
for
then you can
any
go to Bear
travel.
Valley.
I'm going to be on conference call. What's in Bear Valley?
It's the emergency, Mountain Valley Emergency Medical Service meeting.
I got it. I'm on the executive committee of CSAC, so I'll be on the conference call for that. Tom, you go to Bear. Why? Just pretend like you're going
You
to
wanna-
Highlands Lake to see Charlie Tryon
You can
and
speak,
Monty Wolf.
you can speak at the Lookout if you want, in Hogan.
Thank you.
Well, we'll work it out.
We'll work it out.
All right, Mr. Lawton, do you have anything for us this morning? Mr. Jones?
On Saturday, when you're on your way back from Arnold, you should stop at the Habitat Barbecue in Murphy's Park. Starts at 5 o'clock. Lucy Thine has, as usual, enlisted me and Skip Batchelder and Jim Heminger to do the barbecuing of a couple hundred chickens. And so that's Saturday at Murphy's Park, 5 o'clock.
Are you going to do the plucking too?
No,
No.
I'm just doing the barbecuing.
Are you going to wring their necks?
No.
Madeline?
You
All right.
were at, wait a minute now, she was at San Andreas Music in the Park last week. How was it? Was that you wearing a funny hat and collected money? We're dancing though.
Would you?
No. I was sitting, drinking wine, and eating cheese and bread.
Okay, that concludes the public portion of this meeting. We will be going into a closed session. I suppose we'll do that in County Council chambers. Leaving things set up here, we announced earlier that we might have something to announce after that session, so 20 minutes. I'd like to call the meeting back to order and report out on the actions of our closed session. There was one point in the closed session where this chairman was admonished for doing something that another board member said that I shouldn't have done. So in consideration of that, I would like our vice chairman to make the announcement of the action of the closed session, because I certainly wouldn't want to do anything wrong here or misreport it. So, Vice Chair Callaway, would you like to give the report?
No, you can do it.
Are you sure?
Okay, guys.
Okay.
You're holding up lunch with this discussion.
I apologize for being agitated, gentleman and lady, but some things just irritate the crap out of me. Okay, we have had a closed session wherein we were discussing the accommodations or the budget modifications that were made in order to get agreements with the, not SEIU, but the DSA. And there were 3 units of law enforcement. Perhaps County Council Jones can clarify
Sure.
the nature of the settlements.
The board adopted in closed session by unanimous vote 3 resolutions. One is approving a side letter to the memorandum of understanding between the County of Calaveras and the County Deputy Sheriff's Association. Another one approves a side letter to the memorandum of understanding between the county and the Sheriff's Management Unit. And thirdly is a resolution approving a side letter to the memorandum of understanding between the county and the new union, the Calaveras County Public Safety Employees Association. Those were the three actions that the board took.
Okay, thank you for reading that. I think that concludes our report, except Supervisor Tryon has.
I would just like to give one comment. I voted, it was a unanimous vote. I did vote to approve the agreements. What do you call them? Modified agreements, whatever it is I approved. What term do you use?
Side letters.
Side letters. However, I am deeply concerned about and was opposed to moving slightly over $100,000 in vehicle license fee money from the Public Works budget to accommodate funding for the side letters. I think the Public Works budget has been pretty thoroughly decimated. I think we're going to fall further behind on just basic road maintenance. I have asked for a study session and have Public Works before us to go over, now that the state budget's adopted, as to exactly what we're going to have for services over the next fiscal year, including snow removal. So I hope that study session gets scheduled and gets back here before the board. But I do have great reservations about moving vehicle license fee money from the Public Works budget, which is the road budget, into the general fund budget. Thank you.
Supervisor Walensky.
I also wanted to share not a concern but a hope. We have 3 agreements before us, and yet agreements for the balance of the workforce not yet here. It's my hope that people will take a close look at these agreements as they become public, and that the rest of the Calaveras workforce will respond in similar spirit.
Any other comments? Okay, thank you very much for sticking around for the announcements. Do you have any? Would you like to say something, Mr. Stoughton?
Yeah.
Come to the podium.
In the Sherman closed session, it mentions the SEIU. Do you have anything to report out on the SEIU?
Oh, yeah, that's a good point, Carl. Thank you. The report should also reflect that there's no action was taken on that, the SEIU unit.
Okay.
Thank you.
All right. That concludes today's meeting. Thank you.
Copies of the agreements for those who are interested.